In January 1386, a pig was dressed in human clothes, marched through the streets, tried in a court of law, and publicly executed. This was not satire. This was medieval justice. Across medieval Europe, animals were put on trial for crimes. They were arrested. They were assigned lawyers. They were sentenced, and sometimes killed, by courts that treated them as legally responsible beings. This was real, and it happened for centuries. Medieval Europe believed law was universal. God's order applied to humans, animals, and nature itself. When an animal broke that order, justice demanded a response, not symbolism, but punishment. One of the most famous cases took place in Falaise, Normandy, in 1386. A pig had attacked and killed a young child. The animal was seized by authorities and held in custody. A formal trial was convened. Witnesses were called. Evidence was presented. The pig was found guilty of murder. The sentence was severe. The pig was mutilated, dressed in human clothing, and hanged in public. Chroniclers recorded the event in detail. The execution was meant to teach a lesson, not to animals, but to people. Justice, the court declared, must be seen to be done. This was not an isolated incident. In 1457, in the French village of Savigny, a sow and her piglets were accused of killing a child. The mother was convicted and executed. The piglets were acquitted because witnesses testified they had not participated. The court took that distinction seriously. Animals could also be tried collectively. In Autun, France, during the early 1500s, a population of rats was accused of destroying barley crops. The case was brought before an ecclesiastical court. The rats were formally summoned to appear. They did not. The court appointed a defense lawyer. His name was Bartholomé Chassenet, a trained jurist who would later become one of France's leading legal scholars. Chassenet argued that the summons was invalid because it did not reach all rats in the region. When the court issued a second summons, he argued the rats could not safely travel due to the presence of cats. The argument worked. The case was delayed indefinitely. This was not comedy. It was law. Animals were tried in secular courts for crimes like murder or assault. In church courts, animals were prosecuted for moral or spiritual offenses, such as crop destruction. Punishments included excommunication, banishment, or ritual curses. In 1474, in Basel, Switzerland, a rooster was put on trial for the crime of laying an egg, believed at the time to be an unnatural act associated with witchcraft. The rooster was convicted and burned at the stake. The court record survives. Medieval judges were not ignorant. They were operating within a worldview where intention, guilt, and divine order extended beyond humans. Animals were seen as part of a moral universe governed by God's law. Punishing animals publicly reinforced social order. It also reassured communities that chaos had consequences. Trials followed legal procedure. Judges presided. Sentences were pronounced. Executions were carried out by officials. Records were written and preserved. By the 17th century, these trials declined. Legal thought changed. Responsibility became linked to human reason and intent. Animals were no longer seen as moral agents. But for hundreds of years, they were. The medieval trial of animals tells us less about cruelty and more about belief. A world where law was sacred, where justice was public, where order mattered more than logic. The irony is sharp. Medieval courts treated animals as responsible beings, while often denying that same status to many humans. The past did not think like us. And that is the real verdict history delivers. Because sometimes understanding history means accepting that justice once had 4 legs and a court date.